Spend a lot of time out at that point.
Yes.
Good. Just check the class. Okay, good. Just want to make sure. Thanks. Devin, you want to come verify? No, trust you, check. He's slippery, that fella.
I noticed that, yeah, it's nice.
Hear you. The state of Michigan Board of Claims now in session. Presiding the Honorable Douglas B. Shapiro. All persons having business herein, give attention, go on here, and they shall be heard. God save the United States, the state of Michigan, and the Honorable State.
Good morning, everyone. We're here for the final approval of class action settlement in the case of Bauserman and Bro, individually and on behalf of a class versus State of Michigan Unemployment Agency. It's Court of Claims number 2015-202MM. Welcome, everyone. I have reviewed the entire materials that were sent. I've reviewed the motion for final approval, along with all the exhibits and the proposed order granting final approval. Before we go into hearing from counsel, is there anyone here who's has come to object to the settlement? One lady or two people? I'll have you come up. I just wanted to get a sense if there was someone there.
This is my husband.
All right, well,
He's just
very good. You're both welcome. Thank you. And when we get to the appropriate point in our hearing, we'll have you come up to the podium if you have objections to state, okay? All right, who's going to make the, I presume we have some type of presentation from plaintiff's counsel.
Yes, Your Honor. I will be beginning with the
All right, well, come on up to the podium so we can all hear you. And if you just state your name for the record and P number when you get up there. And then I've got a question. But now go ahead. Just go ahead.
Good morning. My name is Jennifer Lord, P46912, and I would like to introduce my co-counsel, Michael Pitt, Beth Rivers, Kevin Carlson, and Ban Jabbar.
Welcome. Thank you for being here. And go ahead. You can proceed.
First of all, we'd like to thank the court for shepherding this case through a long and difficult process. We appreciate your guidance and we appreciate your ability to communicate quickly with both of the parties and assist us in this process. We'd also like to thank many of our clients who are watching on the live stream. They've been patient, they've been persistent, and we really appreciate their support. This motion is unopposed, and it is the final step in a process that began 8 years ago. This is an important and groundbreaking case that not only changed the landscape of civil rights law in the state of Michigan, it resulted in a settlement in which every single eligible class member will receive an award of more than 100% of what was seized from them. This is not the typical class action where someone gets $22.50 from AT&T. These are going to be awards in the thousands of dollars. Kevin Carlson will describe the allocations to the clients and how the money was derived. Ban Jabbar will describe all of the due process issues.
Okay.
We thank you for your time.
Thank you.
Thank you, Your Honor. Kevin Carlson, appearing as class counsel for the plaintiff class. The gross settlement amount in this matter was $20 million. I'm going to give you just a high-level overview of where the numbers ended up, even though to some extent these numbers are still subject to change. Additional costs will be incurred in the final administration process, including some taxation payments and some overhead that'll affect the final numbers. From the time the money was deposited through December 31st, 2023, the fund accrued interest in the amount of $997,028.46, resulting in total deposits to the bank account of $20,997,028.46. From that amount, various expenses were incurred and deductions were made out of that amount, including estimated tax payments in June of 2023 and again in December of 2023 for $100,000 and $105,000 respectively. Service awards of $15,000 each to the named class representatives. Grant Bauserman and Teddy Bro will also be deducted. And attorney fees will also be deducted. And the amount that we have in our motion is $6,637,608.33. There are administration fees currently at $444,563.51. And then there are other associated fees, including bank fees of just over $400.
What are the administrative fees? I'm sorry.
$444,563.
And what are those involved?
And 51 cents. Those are primarily payments to the QSF administrator and the claims administrator for administrating the various notice activities.
Okay.
And there are other associated fees and costs, including bank fees, fees to Megan Norris, the special master, and other costs. The remaining net available settlement fund is $13,219,006.37. In the preliminary approval order, the court approved the creation of 2 funds for compensation of class members. The first fund was called the Economic Loss Pool. The amount of money approved for the Economic Loss Pool was $8 million, and that amount was set aside. It grew with interest to $8,812,677.59. Actually, in addition to interest, Your Honor, estimated taxes also had to be paid on the interest that accrued as to that amount. And a deposit of $500,000 was also made and added to the economic loss amount. That $500,000 was preliminarily approved to be set aside to cover administrative expenses and costs. We had anticipated more costs than were actually incurred. We anticipated that we might need bankruptcy counsel, tax counsel, more expert, economic expert costs than we ultimately needed.
Let me hold you for 1 second. On whose behalf are the taxes being paid?
The-
Is this the, go ahead.
So we set forth in the proposed final order and in our motion that the fees are being, my understanding is that the trust account has a tax ID number. And so the trust is responsible for taxes.
Okay.
The claims
On
administration.
the interest.
On the interest.
Okay.
That's correct. That's correct. And because ultimately the administrative expenses came in at less than we anticipated, the expenses were able to be taken off the top, and the $500,000 and set aside was returned back to the fund for the benefit of the class members. For economic loss claims, there is $8,812,677.59 available for distribution to registered class members. That leaves us with the following numbers as to economic awards. A total of 8,205 class members were identified based on discovery in the form of a database that was produced cooperatively by the state of Michigan through the Attorney General. 3,206 class members submitted registrations. All 3,206 registered class members will receive economic awards. The amount of each economic claim varies from class member to class member, but when all 3,206 economic claims are aggregated and added together, the total actual claimed economic loss was $5,159,693.27. And the average claimed economic loss amount is $1,923.82. But because the economic loss pool is funded by $8 million or more, and the amount of the actual claimed economic loss is just over 5.1 million, there's an additional amount of money in excess of $3 million to be distributed in equal shares to the 3,206 registered class members.
Divided equally rather than prorated.
Divided equally instead of prorated, and after accounting for interest and taxes. We're calling this a supplemental award in the final approval order and the motion for final approval. And the additional amount of equal shares will be about $1,139.42 per registered class
How much,
member.
1,000,
$139.42.
that's the excess award above and beyond the actual claim.
Correct, correct. Not prorated by amount of loss, equally shared amongst everyone who
Gotcha.
registered. Yep. So the economic loss pool will continue to accrue interest until the funds are actually distributed and paid out. And that interest will be transferred to the State Bar Foundation as a CPRE award. Those are the numbers, top line for economic loss awards. And now we'll talk briefly about hardship awards. The court approved a fund of $4 million for hardship awards, which accrued interest and grew to $4,406,338 after interest and taxes. Hardship awards were based on points in accordance with the approved plan of allocation. Hardship claims were received along with supporting documentation and approved for 969 registered class members. A total of 4,819 points were awarded, and thus the value of the point, using the amount in the fund as the denominator and the number of points as the numerator, the value of the point is $914.37. And again, while the amount of hardship awards will vary from registered claimant to registered claimant, the average hardship award is estimated to be $4,131.80, with some receiving less than that, some receiving more, of course. We've prepared a settlement fact sheet summarizing these calculations so that they're available to class members, the media, or anyone else who is interested. Unless there's any questions about the numbers, I'll turn it over to my
I just
co-counsel.
had one question,
Yeah.
Counsel, which, and this may be something that was corrected because I saw that was corrected. I have, let me find it here if you would. So in the motion, the
Mhm.
corrected motion, page
Mhm.
21, it lists in the calculation, actual cost as the date of the fairness hearing is 87,174. But in the paragraph above it, it refers to 38,664. So I just want to make sure I'm working with the right number.
Yeah, the correct number is should be the greater of the two,
The
Your Honor.
87,000.
Yeah, let me see.
Okay.
Yeah, that's correct,
Okay.
because that includes the amount.
The payments to the administrators and.
That's right, because some of those costs were reimbursed or are accounted for or reconciled in reimbursement out of the total deposits in the account,
Mhm.
and some of them were still unreimbursed.
Okay,
And so those previously unreimbursed costs have been added back into the pot.
thank you.
Yep, thank you, Your
That's the
Honor.
only question I have now.
Oh, and one last thing with regard to finances, Your Honor, we will be submitting a post-distribution accounting
Right.
due within 42 days, which should reconcile the final numbers of any additional costs, interest and taxes on interest that have to be paid. These numbers will all be net of those costs that could affect them on the margins.
I have two other quick questions. So, of course, the 42 days will run from the date that I sign the order. And I'm a little confused whether you wanted me to sign the order today or there's something else in the schedule that suggests I'm supposed to sign it a week from now.
No, there's nothing that says you need to wait.
I was confused. then.
Okay, all right, sorry
Okay.
for the confusion.
And my only other question is I reviewed the proposed order with some care
Mhm.
and I don't have any problems with the proposed findings. My only question is whether you want me to go through those on the record or if it'll be sufficient for me to simply make reference to them and sign the proposed order, assuming there's no difficulty between now and then.
I would defer to you, Your Honor.
Okay.
We're not going to insist that you read through it letter by letter on the record.
Okay. Thank you. Yes.
Period. That will begin to run from the date the checks are issued to give people a chance to cash them.
Thank
for
you.
us to track which checks are returned.
Thank you very much for the correction. Anything
Thanks.
else, Ms.
No.
Crawford?
That's all. Thank you.
Yes,
Good morning, Your Honor. My name is Ban Jaber. I am a part of the,
I'm sorry, I just didn't hear you. Let me turn myself up here. Go ahead, say that again.
my name is Ban Jaber. I'm part of the team of attorneys at Pitt McGee. I've been working on the case since the beginning of the settlement administration process in November.
Is Mr. Bear, is that right?
Jaber,
Jay
yes.
Bear, thank you.
Yeah.
Okay.
P number 85451. Your Honor, I'm here to inform the court as to the due process and all of the ways that counsel ensured that those are prioritized throughout the duration of the claims administration process. As Your Honor may know, there are two funds that were described in the plan of allocation, the economic and the hardship fund. The plan of allocation used the data that was provided by the Unemployment Insurance Agency to identify and contact known class members who fit our class definition, meaning that those individuals were accused of fraud sometime between 2013 and 15 and experienced an initial taking on or after March 9th of 2015. And it identified the type of taking that they endured, the amount, and a refund or a repayment by the agency, if any at all. So using this data set and beginning in February of 2023, the claims administrator Analytics Consulting contacted class members in a plethora of ways. It was via email, US mail, phone calls, voicemails, text messages, and targeted social media ads. To encourage registration, and beginning in March of 2023, class counsel as well as dedicated staff and legal clerks at Pitt McGee placed thousands of phone calls and emails to class members, encouraging their registration and informing them of the settlement. And crucially assisting them in registering in one of three ways that was most accessible to them. So that was either over the phone, on the court-approved website, or via mail. And class counsel was largely successful in this effort with a 39% registration rate of known class members who were able to recover more than 100%, as was previously referenced by co-counsel Kevin Carlson, and that was simply by registering, and that was of their economic loss. Efforts with respect to hardship claims began in March of 2023, and in the winter of 2023, class counsel working with Analytics Consulting drafted, mailed and emailed a letter informing class members of the existence of the hardship fund and how to submit a claim and encouraging them to do so. In the spring, class counsel, again with our dedicated staff and legal clerks, placed more than thousands of calls and emails to class members informing them of the hardship fund, of their right to submit a claim, and earnestly encouraging them to do so, to be compensated not only for their economic loss, but for the hardship that they endured as a result of the fraud accusation and the taking. In May, class counsel advertised, recorded, and published a live informational session via Zoom that informed claimants exactly how to perfect their hardship claim. And we actually took live questions from the audience during that time to be sure that the information that was being disseminated was as relevant and responsive as possible. And so this tutorial actually remains accessible to this day on our class website. In the summer of 2023, class counsel hired 3 claims analysts to receive and process hardship claims, as well as initiate calls to class members to aid in their filing of hardship claims. And claims analysts that were closely supervised by class counsel put in 40 hours a week for just under 3 months, assisting claimants to describe in robust narratives about how their living arrangements, transportation, financial health, relationships, mental health, job security, and lives in general were completely upturned by the false fraud accusation, as well as the collection activity. And as a result of these enduring efforts, class counsel was able to assist nearly 1,000 individuals to secure hardship claims who otherwise would not have received as high an award or would not have received one at all. After that, we undertook a careful review of every single hardship claim that was submitted and assigned a point value ranging from 1 to 10. The average value of a point, as was previously referenced, is about $914 according to our latest calculations, and the average award, which varied, was $4,131, and in total, we were able to distribute that whole hardship fund across the individuals that submitted claims. And upon notifying class members of their hardship claims, they were also informed of their right to submit an appeal to our special master, Megan Norris, for a objective, albeit final and binding review of their awards. She undertook a very careful review and decided to award 6 appeals for a modest upwards point adjustment. Lastly, it's important to note that class counsel views their obligation to class members as a continuing duty. Throughout the claims process, we received probably more than 20 inquiries per week that were promptly responded to. Since the close of the claims process, we receive about 5 to 7. Those questions are, about payment, timelines, and honestly, sometimes thanking us for our hard work, which is never expected, but it's always appreciated. And those are still promptly responded to. And so throughout the last year and a half, we've worked really closely with our partners on this project, as well as our claimants. And we feel that we have undertaken every effort to ensure that the due process of claimants was prioritized, and we think that our results reflect that effort. Does Your Honor have any questions at all?
No, I don't. Thank you.
Okay, thank you so much.
Anybody else from the class who's going to present? All right. Oh, Mr. Carlson, you're back.
Just
Okay.
briefly and procedurally, Your Honor, we're working with the Attorney General to make sure that every final payment that goes out will be accompanied by a waiver and release, the form of which we've put into the record, and that settlement funds can only be received after the settlement agreement and release is signed and returned as consideration for receiving a payment. So unless there's other questions from the court, we submit it for your approval.
Very much.
Thank you.
Ms. Taylor?
Good morning. May it please the court, Assistant Attorney General Debbie Taylor on behalf of the defendant, the Michigan Unemployment Insurance Agency. Just a couple of preliminary issues, Your Honor. I would like to echo what Ms. Lord said. The court's made itself available for us during this lengthy process, and I, on behalf of the Attorney General's office, greatly appreciate your efforts here. So thank you.
Thank you. I think the efforts were mostly all of yours, but I appreciate it.
And I also have to give a shout out to Mr. Pitt's team. It was a pleasure working with the group. This was not an easy case when it initially started, but working with class counsel here, it was really a process that we kind of went through. My office tried to assist whenever we received calls. I know that counsel was up talking about the due process issues. We had a few calls. We would send them off to the claims administrator. That was a process that was built into my office to assist with all of that. Other than that, there were a couple of calls directly from Mr. Pitt. Of course, I sent them on to Mr. Pitt to talk to them. So we did try to work together, so it has worked out well. So in as far as the documents are concerned, Your Honor, I've reviewed thoroughly all of the documents. Counsel was kind enough to send them to me with sufficient time to allow me to review them word for word. That's why all the documents were filed as unopposed, because I didn't have any concerns, any issues that were brought up. We quickly revised the documents. They were all taken care of. So I don't have any objection to any of the documents that have been filed. And I've also reviewed the order granting final approval of the settlement and would ask the court to sign. I have no objection to that order at all. Any questions, Your Honor? Thank you.
All right. I know we have one person in the courtroom who wants to speak in regards to an objection. Is there anyone else who has here today to object to or raise questions regarding this settlement that's just been put on the record? All right. We have the one young lady here, and I'll have her come up in just a minute. Let me just ask counsel, have you heard from anyone who is not here today who has suggested that they have an objection to raise?
Yeah.
Thank you. Anyone at the AG's office?
No, you're right.
All right. Now, ma'am, if you would come forward to the podium and tell me your name.
Thank
What is your
you.
name, ma'am?
My name is Nakia Brown.
Could you spell that for us?
It's N as in Nancy, Akeya.
Nakeya.
Yep. And
Last name Brown.
yes, spelled just like the color brown.
All right. Now you're going to be making some statements to the court now. So I'm going to put you under oath. Okay.
Okay.
All right. If you'd raise your right hand. Is the testimony you're about to give at this hearing the truth? Do you swear or affirm that the testimony you're about to give at this hearing is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you very much, Ms. Brown. Go ahead and tell us your concerns.
Well, I would like to appeal the decision that I was denied for the UIA settlement. And
For the what settlement, ma'am?
This settlement, I was denied
Okay.
pertaining to
You were
the
denied
settlement.
anything or denied the hardship?
I was denied everything.
Okay.
So I didn't really know about the hardship until later.
Okay.
So I just want to appeal.
So you
this
did
decision.
submit a claim?
I did submit a claim.
And what dates were involved in your claim, if you know? I mean, in terms of when you allege that monies were improperly seized, or they were relevant to what? I'm asking because there was a cutoff point in terms of how far back this whole thing could go.
I was denied back, let's see, I think it was 2014.
I mean, at what?
When I was working for McLaren Regional Medical Center.
And what
And-
was it in 2014 that you allegedly received benefits to which you were not entitled, but now turns out you were?
Yes.
Okay. Continue.
So I actually wrote a statement about it. If
You can
I
read
may
it if you'd
repeat
like,
it.
and if
Okay.
it's not terribly lengthy.
Okay. It's not too long. I hope it's
Okay,
not
go
too
right ahead.
long. I would like to appeal the decision to disqualify me from. I don't want to be disqualified from the settlement. I was unjustly fired from my job at McLaren Flint Regional Medical Center. I was told that I would not be denied unemployment. However, I was denied after receiving the full unemployment payments, and my taxes were garnished from 2015 to 2019. And my husband and I was evicted from our apartment. We had to move in with family, which caused a financial strain on the family and also my husband and I, which resulted in a lot of friction in the family and a lot of arguing about money, since we really didn't have much of it. And that caused a lot of stress and anxiety for me as well. And so we finally made the decision to move out of state in hopes of finding something better. We moved in with family in Fayetteville, North Carolina. And that experience was especially hard for me because right before I left, my mother had surgery, and I'm the oldest, so I usually help a lot with her care. And she had severe complications with the surgery, and I wasn't there. I was in the process of like being on the road, hearing about the complications, and that put me through a lot of stress and anxiety. And we finally reached there. I did find work in the field that I work in. However, I wasn't able to keep that position due to me having an allergic reaction to the solution that was the patients. I'm sorry, let me go backtrack. I worked for Fresenius dialysis company, and the solution that they used to dialyze patients was a bit too strong for my system, and I wound up having complications with that to where I couldn't work for months. And so we was having difficulties there. Even my husband had problems with finding work there. And so we moved in with another family. Had family in Tallahassee, Florida. And so we've been there since. And however, I've been having a hard time with dealing with my stress and anxiety. It was like a snowball effect when it came to me trusting in companies and dealing even with certain ones, working with them. And it reached the boiling point of me eventually having 4 mini strokes. I had 3 on my left and 1 on my right. And that prevented me from working for a few years. And I finally started being able to go back to work, to find something back in 2023. However, I'm still dealing with stress and anxiety. I did get help. I sought out therapy to help me with my stress and anxiety, but I'm still working on it. Things are getting better, but I'm still experiencing all of this from a snowball effect from me leaving my home and having to leave my sick mother. And I often keep up with her, and she tells me about her health concerns, but she's doing better than what she has been doing. So I would like to still be part of the settlement, or at least get some portion of the money, whether it's like due to the unfair garnishment of my taxes, or compensating me for the hardship that I've experienced because of everything, me leaving my home and leaving my family, my husband and I just uprooting and leaving our lives from Michigan. And we just drove here from Tallahassee, Florida.
I was about to ask, did you come all the way from Florida for the hearing?
Yeah, it's an 18-hour drive. We have family in Ohio, so we stopped there for the night and then continued the rest of the way Sunday evening.
So tell me a little bit now about when did you hear about this, and did you file?
Yes.
Did you register to be a member of the class that would receive funds, and what happened?
I received something back in, let's see, I think it was sometime before September.
Of what year?
Of last year in 2023.
You
It
hadn't
says,
received something before then, or any contact prior to September of 23?
No, I've gotten a lot of notices from UIA saying to pay back, pay
No,
back
I'm
my
talking
garnishes. I
about
got a lot of those.
Did you receive any notices either from plaintiff's counsel or some other source that this litigation was proceeding, and if you wanted to file a claim, you had to do so by such and such a date and in such and such a fashion?
I did. I received that, and I forgot what month, but I did receive something and I turned it in. And
Was that in 2023?
Yes, it was in 2023. It was before September 15th. I responded to that in a timely manner, and then I was denied. So
And what's your understanding of why you were denied?
It said that I did not meet the criteria.
Okay.
So I appealed that decision. In the documents that I had, it said I had to appeal to Miss Megan Norris.
Mhm.
And so I submitted that, and she too denied me. And so I'm here now appealing those decisions.
You have any correspondence that you received in relation to the denial? In other words, a letter or some email saying you're not getting. Mr. Carlson, you have it?
Yes.
Just reapproach Ms. Brown. She was kind enough to share an amended claim notice that she got. We want to make sure she gets that.
Yeah, I do have that, and I also have the letter from Miss Norris denying me of the claim. Where's my other document?
You can take a moment to find that. We're not in a terrible rush.
I do have that.
Okay.
I have this, and also this letter from Miss Norris. Do I come and give it to you, or?
Yeah, you can just approach the bench, hand them to me. I'm gonna look at them and I'm gonna give them back to you.
Okay.
Okay. Thank you. Give me just a moment, please. I see. All right, my understanding just from reviewing Ms. Norris's letter is that one of the requirements in order to receive funds as a member of the class is that you have demonstrated or provided some proofs that the improper, if any, action on the part of the UIA was the result of auto adjudication. In other words, a purely computerized process, and it appears that Ms. Norris and I presume plaintiff's counsel who reviewed it concluded that that was not the case. I don't have any questions for you at the moment. I'm going to give this stuff back to you in a couple of minutes, but if you take a seat, I'd like to hear from plaintiff's counsel and then the state if they have any comment on your objection. Okay. Mr. Carlson or somebody else from the plaintiff's side?
Sure, Your Honor. I first of all, I want to thank Ms. Brown and her husband for making the trip. I know that the court does everything it can do to make sure that, you know, Ms. Brown and her husband feel welcome in the proceedings, and we want to make sure that we extend the same courtesy to her out of respect for what she's been through and the injuries she suffered and the hardship that she's experienced. I mean, it's just an unfathomable experience. And if it were up to all of us, just strictly from one person to another, she would be fully compensated for all of that. Okay. We've been trying this morning since we met Ms. Brown to gather some information about what happened just procedurally and process wise with her claim. And what I've gathered from the claims administrator, Analytics Consulting, is that Ms. Brown was not on the database of known class members.
Which was generated
By the state of Michigan and provided to us and to the claims administrator. And when just in terms of context, it might be helpful for Ms. Brown and her husband and the court to be aware of this aspect of the case.
Sure.
When we first brought this case, what was it, 2015, 8.5 years ago, we believed that there may be as many as 40,000 class members who had experienced takings as a result of the auto adjudication process. Midas went online in 2013. Our client, Grant Bauserman, came to us in 2015 because his federal income tax refund had been intercepted and garnished. We filed the case within 6 months of when his money was taken. When the Michigan Supreme Court finally ruled in 2019 that the claims had accrued within 6 months prior to the filing, it limited the scope of our plaintiff class to those people who had experienced their first economic taking on or after that date in March of 20.
And the taking
2015.
refers to informing the person that they owed the money or the garnishments.
Correct. Not informing that it would be taken, but the actual taking itself. So the
okay.
intercept, the garnishment, the actual seizure of funds.
Right, and it was within 6 months of the filing date. That was how far back you could go.
Back, exactly. So instead of dealing with anyone who had experienced a taking, however damaging it might have been, and we all know that there were some terribly damaging takings that took place before the accrual date, we were limited in terms of our jurisdiction and representation of the class to only going back to that March accrual date. And so that
was, tell me again, that was March.
March 9th, 2015.
March 2015
March 9th of 2015.
and we go 6 months back, or that is the 6 months?
No,
back?
that we'll sit, with the lawsuit was filed on September 9, 2015.
Gotcha.
We go
Okay.
6 months back from that date to March 9 of 2015. And that drastically narrowed the number of people, likely including Ms. Brown, who would have been known and eligible class members. And so clearly more people were aware of our lawsuit and believed that they had claims, only to learn that by virtue of the way the Michigan Supreme Court interpreted the accrual standard, it had narrowed to about 20% of its original expected size. And so Ms. Brown, no fault of
So
her
let me
own.
stop you again. So my understanding is that the Supreme Court's ruling was that the first taking, in order to be an eligible member of the class, your first taking had to occur no earlier than March 9, 2015.
That's correct.
Okay.
That's correct. And, through no fault of her own, Ms. Brown, being aware of the class action settlement, submitted a claim for loss to the claims administrator, was denied. She appealed it, was within her rights to appeal it, and the appeal was rejected in accordance with the due process procedures
Do you
set
know
forth.
when the first garnishment or seizure of funds took place?
I don't know, and I'd be very interested to know that number, just to confirm that she's on the right or the wrong side of the accrual date. And the appeal letter, the denial letter, was sent to her on August 24th, which I think is probably one of the records that she shared with Your Honor. And that was it. The reason why she received an amended notice of claim is because by virtue of attempting to register for a claim, even though she was not an eligible class member, she would have been assigned a claim number. And the system would have sent her forms by virtue of having that claim number in the system.
Let me just, I'm looking at Ms. Norris's letter. I don't know if you have a copy there in front of you.
I do not, Your Honor, no.
Would you like to? You want me to send?
I'd be very interested to see it, yes.
Okay. Shall we take 5 minutes and we'll have this copied and I can give it to you?
Yeah, thank
All
you, Your
right.
Honor.
We're going to adjourn for a few minutes while we make copies of these documents for everybody. And we'll let you know when that's done.
Okay, thank you.
So I'm going to have my assistant make copies and I'll give you a few minutes to look at them and see if there's any other information you want to give me before I make a determination regarding Ms. Brown's objection. All right, so I'll be back out shortly.
Court will now recess.
you have the site for Bauserman handy, anybody? All right, thanks. All right, and Rick, will you just let me know when that.
Yes, sir. All rise.
Thank you, everyone. You can be seated. We have copies of the Miller Canfield letter dated September 2023. And my clerk will be giving copies right now to Defense and Plaintiffs Counsel and the original back to, oh wait, hang on. I think this is the original, is it not?
No, I haven't.
But these also go to her, go back to Ms. Brown.
Yeah.
Okay. So Ms. Brown, I'm gonna let the two attorneys read these and then respond in any way, but could you come back up? I have one more question for you. So do you know or have in your notes when the state first seized your money, either by garnishment or seizure of your taxes or tax return, tax
let's see.
refund? I mean.
I think I got a notice in, I got a notice, I think in 2015 about it.
You don't
but
have it with you?
If I do, I can look and see it in my
Okay, go
documents.
take a look.
Okay.
Thanks. And you folks take as much time as you want to look at that stuff. And then if I'd like to hear from both counsel and if any response or any additional questions from Ms. Brown. I did review the Bauserman opinion, and it is correct that whether rightly or wrongly, the Michigan Supreme Court did determine that this fell within the 6-month notice requirement. And so that the date of the first seizure had to have been no earlier than March 9, 2015 in order to qualify to participate in the settlement. And that's a decision, Ms. Brown, I don't know ultimately whether it applied, where your date will fall out, but that's a decision that comes from a higher authority that none of us can challenge. And I guess my question for counsel, if you know, and you may need to do additional review of your materials, is it looks to me on page 2 of the letter that the first intercept of taxes was April of 2015, which on its face would seem to come after March 9 of 2015. So that's what I want to figure out.
Yes, Your Honor. If we're reading from the same place, the second bullet point on the Miller Canfield letter seems to say that the tax refunds were not intercepted.
One moment. Where are you reading from?
The second page of the Miller Canfield letter, the second bullet point.
Right. Your tax refund was not intercepted.
Right.
And you received regular statement.
Right. So
I see.
Miss Norris's process as special master handling the appeals was independent from our office. We did separately receive information from Ms. Brown that we've been able to locate in our system, and we've been reviewing it here while Your Honor was in chambers getting copies made of the Miller Canfield letter. We can speak to the fact that we took every direct contact from class members very seriously, as we did with Ms. Brown. And in re-reviewing the materials that she did provide to us, we would indicate for the record the following. According to the documents that we received, Ms. Brown's employment with McLaren ended, as she informed the court previously. She was awarded benefits based on her initial claim for unemployment insurance. That eligibility determination, whether she was eligible or not for unemployment in the first place, was at some point in the administrative process reversed through a determination of an administrative law judge that she voluntarily quit. And
okay, so the initial determination was that she was eligible, and then the ALJ
Reverse.
reversed that on the grounds that she had voluntarily quit.
Voluntary quit. And so the way the process works is my understanding, and Ms. Taylor can of course correct me if I'm misapprehending in any way, is that under the law, once someone makes a claim for unemployment, if just on first glance they're eligible, payments have to be made.
Right.
And then the process goes through, and then if they're redetermined to be ineligible, then the money is clawed back by the UIA. And so it appears that Ms. Brown's award was unfortunately vacated, UIA clawed back.
In other words, and so there was actually a challenge from the employer, it sounds like.
That sounds like there was, right? And so the underlying issue was a determination of ineligibility by a human, not an auto adjudicator. And because the underlying cause of her losing the benefits was a determination of ineligibility, and under our class definition.
And not fraud.
And not exactly. The class definition is narrowly designed to include determination of intentional misrepresentation. The determination of ineligibility by an ALJ does not bring her within the purview of the class settlement. That's.
And at this point, is based on what you're telling me, do you want me to approve the settlement as before me today, or is there anything else you want to do in regards to Ms. Brown's objection?
This would not, in our view, affect approval of the settlement today.
Okay.
No.
Or the distribution.
Right. Yeah, correct. And with all, I mean, honestly, with all due respect to the hardship suffered by Ms. Brown, I can't even begin to speak to what that must be like.
Okay.
So, thank you.
All right. Ms. Taylor, anything from you as to Ms. Brown's objection?
Not necessarily, Your Honor. I was not involved in the registration process or the appeal process, so I rely on class counsel. And Mr. Carlson has adequately described the process. The ALJ unfortunately disagreed that she was entitled to the benefits, so it doesn't sound like she met the minimal eligibility requirements for the class. Thank you.
All right, Ms. Brown, would you come on back up? So, you're probably following quite carefully what's going on, but I'm just going to say it again, just to make sure that for my satisfaction that you understand. So the issue is I initially thought that it might concern the date in which there was an initial seizure by the state of your monies, and that might have put you into the non-compensable group. In fact, that doesn't appear to be the problem. The problem seems to be rather than having a computer, as the claimants have, simply determining by some measure that remains mysterious that you were ineligible and had committed fraud. What actually occurred here was that your employer, which I think you said was McLaren, disputed your right to unemployment benefits.
Yeah.
And in fact, they said you had voluntarily quit.
Right.
And ultimately that matter went to a hearing before an administrative law judge, who made a determination that in fact you had voluntarily quit, whether rightly or wrongly, I don't know. But that was the determination. At that point, you were ineligible to have received the benefits and had to pay them back based upon a genuine ineligibility, at least as determined by the system. And so you are not eligible to receive compensation from this class action. I apologize for that. Given what you've gone through, and obviously it seems like a terrible injustice that caused you a lot of pain and suffering. But that is the requirement that's defined by law and by the Supreme Court. Now, having said that, before I overrule your objection, I'm open to hearing any other thing you want to tell me or any other materials you want to bring to my attention.
Yes, I did try to get in touch with a lawyer pertaining to that. I forgot the name of the lawyer. I have the paper of the lawyer that I had encountered, but my response to them was that I did not quit. And even though I kept appealing their decisions, they refused to accept what I was saying. The letter that I gave them, it shows who I contacted, the managers and the supervisors that were involved in the decision to keep me off the schedule to make it look like I voluntarily quit when I did not. And that was the situation. And so they, starting 2015, took my tax returns, but I did not voluntarily quit.
I understand, and I don't doubt the honesty of what you're telling me.
Mhm.
Unfortunately, the legal determination as to whether or not you were deemed to have voluntarily quit or have been discharged has been made by an authority that I don't have the authority to overrule or even to take a look at the basis for their decision. And so as we stand here today, based upon the determination of the agency and the administrative law judge, there was a conclusive and final determination that by law that you had voluntarily quit. And given that, you are not eligible within the confines of this class action case. And therefore, I have no choice but to overrule your objection. And I appreciate very much that you and your husband came all this way and you went through great personal hardship as a result. Regrettably, there's nothing I can do to change what has happened in the past, and so I have to deny your objection to the settlement.
Okay.
All right, thank you very much. All right. Is there anything else anybody would like to present at this point?
No, thank you, Your Honor.
Thank you very much. All right. Once again, I have reviewed let me find it here. Okay, I reviewed the order granting final approval of class action settlement, which was submitted with the motion. It is a 10-page document. I'm not going to go through all of the findings that are set forth in that opinion, in that order. I will note, however, that contrary to what's listed on page 3, there has been an objection to the settlement. I don't know, that was an objection to the notice plan. I'm not quite sure where so that wouldn't be it. One moment. Here, okay. On page 5, it indicates that no objections have been submitted. Counsel, could you prepare a revised order that indicates one objection was received, identify Ms. Brown, and you can state the nature of my ruling, and I will review that revised order and sign it. Having said that, I do agree with all of the findings except that one that are set forth in the order approving the order of final approval of class action settlement and distribution. And I will sign it once I have the revised order. All right. Anything else from, and when do you anticipate I can have that, Mr. Carlson? All right, that would be great. And you'll have Ms. Taylor review it, I assume, and provide a copy, please, to Ms. Brown. All right, very good. So you can submit that through the normal mechanism today or tomorrow, or yes, ma'am. That'll be fine. If you can do it, and you said you can just email me the change. All right, then why don't we do that, and I'll go ahead and sign it once I receive it. And if you send it to me today, I'll be signing it today. Okay. Very good. Thank you, everyone. Is there anything else I can do for you? All right. Let me congratulate all counsel involved. I appreciate the gratitude you've shown me, but you know, I came on at the tail end of what's been a many year process, although I did sit on a couple of the initial cases about the propriety of the UIA's actions. And so I'm familiar with the difficulties, but I congratulate you on a 100% settlement or better for all of those that you were able to properly represent, given the limitations set forth by the Supreme Court. And I congratulate Ms. Taylor on her professionalism in resolving this very complicated and unwieldy matter in such a nice and complete fashion and professionally done. So when I get the order, I'll sign it, and that will conclude the matter until, of course, the 42-day accounting, the post, I guess you would call it the post order accounting that comes 42 days after the checks are issued. Okay, very good. Thank you, everyone. The matter is concluded.